Hello, my name is Barry Lee O'Connor. I'm an attorney licensed to practice law in the state of California. I've been an attorney for over 25 years. In addition, I'm also a landlord. I've been a landlord for 42 years. I represent landlords exclusively. I spend almost 5 days a week in court, one session in the morning, one session in the afternoon, representing landlords. Normally for an unlawful detainer action, it doesn't require a lot of preparation prior to trial. If you're going to trial, sometimes the attorney who is representing you is going to ask you to bring your records. Your records will consist of documents relating prior to the tenant moving in, if the property was remodeled, all repairs while the tenant has been there, all repair requests that the tenant might have made to you, either in writing or orally, and then also what's called a ledger card. And that is a card that shows when the tenant paid the rent, when the rent was due, and how much rent is owed. In an unlawful detainer action, the burden is always on the plaintiff. The plaintiff goes first in a trial. In a trial, there's about 15 questions the attorney needs to prove up the case. All those questions are going to require a yes answer out of you. Please do not expand on answers in court. It opens up doors that you don't want to open. The answers to the questions are always yes or no, unless the judge asks you to explain something. In an unlawful detainer action, it's in a regular court of law, a civil court. You must dress appropriate attire to attend court. Appropriate attire consists of casual business. Do not wear shorts, cutoffs, or tank tops to court. You're also going to have to go through a metal detector. Do not bring excessive baggage with you to court. You'll bring as limited amount of material with you to court as you possibly can. Anything that you have in your pockets are going to have to be emptied out. Your belt's probably going to have to be taken off. In addition, you're probably going to, if you have a purse, the courtroom deputies are going to go through your purse before you come through into the courtroom. So it's best if you do not bring what you don't need to court. You can bring water as far as something to drink, but that's about all you're allowed to bring to court to drink. It's important when you come into the lobby or the courtroom, stay away from your defendant or your tenant. A lot of times at this point there's a lot of animosity. Let your attorney talk to the defendant. Let your attorney try to work things out. That's what you paid him for. Again, it's important that you show up at least a half hour early so your attorney has time to discuss the case with you. When an attorney comes to an unlawful detainer court, many times he has many other cases. What will happen is he'll probably do his hardest cases first. If yours is the hardest case there, he'll do that last and spend as much time as needs to be spent with you. He'll do his easiest cases first. A lot of times there's just motions, continuances, and those go rather quickly. So please, listen to your attorney. Listen to what he has to say, what's important. What you think is important and what he thinks is important is going to be two different things probably. A case is pretty simple. The tenants have either paid the rent or they haven't moved. If they haven't paid the rent, they haven't moved, they have to have a legal defense. And a lot of times in an unlawful detainer action, the tenants won't show up. If the tenants do not show up, there's about 10 questions that the attorney is going to ask. Some of these questions are you the owner of the property? Did you rent the property to the tenants? Did the tenants move into the property? Did you cause a notice to be served? Have they moved out of the property? Do they owe this much rent? Do they owe this much fees? Do they owe this much cost? If you notice, all these questions are going to be yes, the answers. It's important that when you get to court that you just answer yes or no. In most cases, the answer is yes. If you answer more than yes or no, it opens up doors that may not be good for you to enter. So please, listen to your attorney when you get to court, and he'll take care of everything for you. A lot of times when I go to court with somebody, the owner or the witness doesn't even have to testify. So please, the attorney who will come to court with you will be a professional that's done thousands of these cases, and they know exactly what they're looking for and how to do it. If you do have any other questions, you can call our office or you can read the material on our website, and our website is udlaw.net.